Chapter 11 Basic Structure of the Constitution. Emergence of the basic structure. The question whether fundamental rights can be amended by the Parliament under Article 368 came for consideration of the Supreme Court within a year of the Constitution coming into force. In the Shankari Prasad case of 1951, the constitutional validity of the First Amendment Act 1951, which curtailed the right to property, was challenged. The Supreme Court ruled that the power of the Parliament to amend the Constitution under Article 368 also includes the power to amend fundamental rights. The word law in Article 13 includes only ordinary laws and not the Constitutional Amendment Act constitutional laws. Therefore, the Parliament can abridge or take away any of the fundamental rights by enacting a Constitutional Amendment Act, and such a law will not be void under Article 13. But in the Golaknath case of 1967, the Supreme Court reversed its earlier stand. In that case, the constitutional validity of the 17th Amendment Act of 1964, which inserted certain State Act in the 9th Schedule, was challenged. The Supreme Court ruled that the fundamental rights are given a transcendental and immutable position, and hence the Parliament cannot abridge or take away any of these rights. A Constitutional Amendment Act is also a law within the meaning of Article 13 and hence would be void for violating any of the fundamental rights. The Parliament reacted to the Supreme Court's judgment in the Golaknath case 1967 by enacting the 24th Amendment Act 1971. This act amended Articles 13 and 368. It declared that the Parliament has the power to abridge or take away any of the fundamental rights under Article 368, and such an act will not be a law under the meaning of Article 13. However, in the Keshwanand Bharti case of 1973, the Supreme Court overruled its judgment in the Golaknath case of 1967. It upheld the validity of the 24th Amendment Act of 1971 and stated that the Parliament is empowered to abridge or take away any of the fundamental rights. At the same time, it laid down a new doctrine of the basic structure or basic features of the Constitution. It ruled that the constituent power of Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. This means that the Parliament cannot abridge or take away a fundamental right that forms a part of the basic structure of the Constitution. The doctrine of basic structure of the Constitution was reaffirmed and applied by the Supreme Court in the Indira Nehru Gandhi case of 1975. In this case, the Supreme Court invalidated a provision of 39th Amendment Act of 1975 which kept the election dispute involving the Prime Minister and the Speaker of Lok Sabha outside the jurisdiction of all courts. The court said that this provision was beyond the amending power of Parliament as it affected the basic structure of the Constitution. Again, the Parliament reacted to this judicially innovated doctrine of basic structure by enacting the 42nd Amendment Act of 1976. This act amended Article 368 and declared that there is no limitation on the constituent power of Parliament and no amendment can be questioned in any court or any ground, including that of the contravention of any of the fundamental rights. However, the Supreme Court in the Minerva Mills case of 1980 invalidated this provision as it excluded judicial review, which is a basic feature of the Constitution. Applying the doctrine of a basic structure with respect to Article 368, the court held that since the Constitution has conferred a limited amending power on the Parliament cannot, under the exercise of that limited power, enlarge that very power into an absolute power. Indeed, a limited amending power is one of the basic features of the Constitution, and therefore the limitations on that power cannot be destroyed. In other words, Parliament cannot, under Article 368, expand its amending power so as to acquire for itself the right to repeal or abrogate the Constitution or to destroy its basic features. The dunny of a limited power cannot, by the exercise of that power, convert the limited power into an unlimited one. Again, in the Vaman Rao case of 1981, the Supreme Court adhered to the doctrine of the basic structure and further clarified that it would apply to the constitutional amendment enacted after April 24, 1973, that is, the date of the judgment in the Keshwanand Bharti case. Elements of the basic structure. The present position is that the Parliament under Article 368 can amend any part of the Constitution, including the fundamental rights, but without affecting the basic structure of the Constitution. However, the Supreme Court is yet to define or clarify as to what constitutes the basic structure of the Constitution. From the various judgments, the following have emerged as basic structure of the Constitution or elements of the basic structure. Number 1. Supremacy of the Constitution. Number 2. Sovereign, democratic and republican nature of the Indian polity. Number 3. Secular character of the Constitution. Number 4. Separation of powers between the legislature, the executive and the judiciary. Number 5. Federal character of the Constitution. Number 6. Unity and integrity of the nation. Number 7. Welfare state, socio-economic justice. Number 8. Judicial review. Number 9. Freedom and dignity of the individual. Number 10. Parliamentary system. Number 11. Rule of law. Number 12. Harmony and balance between fundamental rights and directive principles. Number 13. Principle of equality. Number 14. Free and fair elections. Number 15. Independence of judiciary. Number 16. Limited power of parliament to amend the constitution. Number 17. Effective access to justice. Number 18. Principles or essence underlying fundamental rights. Number 19. Powers of Supreme Court under Article 32, 136, 141 and 142. Number 20. Powers of the High Court under Article 226 and 227. Evolution of the basic structure of the Constitution. Number 1. Keshwanand Bharti case 1973, popularly known as the Fundamental Right case. Elements of the basic structure declared by the Supreme Court in this case are: Number 1. Supremacy of the Constitution. Number 2. Separation of power between the legislature, executive and judiciary. Number 3. Republic and democratic form of government. Number 4. Secular character of the Constitution. Number 5. Federal character of the Constitution. Number 6. Sovereignty and unity of India. Number 7. Freedom and dignity of individual. Number 8. Parliamentary system. Number 9. Mandate to build a welfare state. Case number 2. Indira Nehru Gandhi case 1975, popularly known as the election case. The elements included under this case are: Number 1. India as a sovereign democratic republic. Number 2. Equality of status and opportunity of an individual. Number 3. Secularism and freedom of conscience and religion. Number 4. Government of laws and not of men, that is rule of law. Number 5. Judicial review. Number 6. Free and fair elections, which is implied in democracy. Case number 3. Minerva Mills case of 1980. It declared limited power of Parliament to amend the Constitution, judicial review, harmony and balance between the fundamental right and directive principles. Case number 4. Central Coalfields Limited case 1980. Effective access to justice. Case number 5. Bhim Singh Ji case of 1981. It declared welfare state, socio-economic justice. Case number 6. S.P. Sampath Kumar case of 1987. It declared rule of law and judicial review. Case number 7. P. Sambamurthy case of 1987. It also declared rule of law and judicial review. Case number 8. Delhi Judicial Service Association case of 1991. It declares powers of the Supreme Court under Article 32, 136, 141 and 142. Case number 9. Indira Swani case 1992, popularly known as the Mandal case. It declared rule of law. Case number 10. Kumar Padma Prasad case of 1992. It declared independence of judiciary. Case number 11. Kyoto Holohan case 1993, popularly known as defection case. It include free and fair election, sovereign democratic republican structure. Case number 12. Raghunath Rao case of 1993. It declared principle of equality, unity and integrity of India. Case number 13. S.R. Bommai case of 1994. It declared federalism, secularism, democracy, unity and integrity of the nation, social justice and judicial review. Case number 14. L. Chandrakumar case of 1997. Powers of the High Courts under Article 226 and 227. Case number 15. Indira Swani's second case 2000. It declared principle of equality. Case number 16. All India Judges Association case 2002. Independent Judicial System. Case number 17. Kuldeep Nayyar case of 2006. It declared democracy, free and fair elections. Case number 18. M. Nagaraj case of 2006. Principle of equality. Case number 19. I.R. Kohlo case of 2007, popularly known as 9th Schedule case. rule of law, separation of power, principles or essence underlying fundamental rights, judicial review, principle of equality. Case number 20, Ram Jethamalani case of 2011, powers of the Supreme Court under Article 32. Case number 21, Namish Sharma case of 2013, freedom and dignity of the individual. And last case number 22, Madras Bar Association case. It included judicial review and powers of the high courts under Article 226 and 227 under the basic structure. Thank you so much.